Assembly Bill 2643, a dentistry general anesthesia healthcare coverage. So this bill would revise the required written informed consent statement with respect to the use of anesthesia applicable to minors to specify that it's required in the case of general anesthesia. Additionally, it revises the content of the statement to require it is to include a provision to encourage exploring non-surgical dental treatment options. Existing law provides that specified healthcare service plan contracts and disability insurance policies and certificates are deemed to cover general anesthesia and associated facility charges for dental procedures if certain other conditions are present. This bill, with respect to contracts or policies issued, amended, or renewed on or after January 1st, 2019, would remove the language that limits coverage to procedures rendered in a hospital or surgery center. This bill was to be heard by the Assembly Appropriations Committee as of this morning, but I've been at this board meeting, so as of now, I don't know if it went to suspense or if it did pass, but I can keep you guys updated once I hear.
So this is one of the bills that was passed out.
Correct, yes.
So the new language now is what Jerry had passed out.
I have a few remarks that I'd like to add at the appropriate time.
Okay, but just
Okay.
to make sure that members are seeing the new language, if you will look on page 3, under
My
Section-
comments are quite general. Okay, this is an interesting bill because it was accompanied by a study done by the California Health Benefits Review Program. And, you know, I didn't know a lot about this, but it turns out that there is a program established by the legislature in 2002 to review new proposed health insurance benefit mandates and repeals. And it's analytics staff from the University of California. They work with a task force from several campuses of the UC, as well as actuarial consultants. And they have their review on a 60-day turnaround, so it's pretty quick. And the idea is to get feedback back to the legislature on these kind of proposals before the bill is formally considered. And they have their own website and I think about a 60-page analysis of the bill and accompanied by studies. And I won't go into too much more than that to say that it's out there. Those who are interested could read it. The really nice thing about it is they use a graded evidence approach, which is kind of the standard now if you're looking at studies and their outcomes. And, you know, they basically use a 4-point scale from clear and convincing down to insufficient evidence. And those all have very specific definitions. But basically the results of the study, and I'll just go down to how they defined medical effectiveness. They found that there was limited evidence that procedures involving anesthesia-based in offices was as safe as effective as that in hospitals and surgery centers. Inconclusive evidence that receiving dental surgery under conscious sedation versus general anesthesia could affect outcomes, and that there are effective treatment alternatives to general anesthesia. However, there was a preponderance of evidence that lack of treatment for conditions such as dental caries can lead to secondary complications. In other words, the treatment's really needed. There's good evidence of that, fortunately for us in the business. And limited evidence, and this is an interesting one because there was consent provisions in here and it speaks to our informed consent process. Limited evidence suggesting that parents, caregivers do not read or have incomplete understanding of informed consent documents, and insufficient evidence to suggest that adding text about exploring non-surgical options to the informed consent would change parental decision-making. So again, you know, I think that's something those of us in practice know, that people have a lot of forms to sign. They don't usually read them. But anyway, there are some safety statistics related to general anesthesia that are described in there. Again, it was a limited review. Their findings was there was limited evidence regarding various delivery models and so on, which is something we know. And their numbers are very similar to what we've heard about during the 2016 anesthesia subcommittee presentation. So I won't go into that unless there are specific questions. But anyway, just a little additional background, which I thought was very interesting and perhaps germane.
Okay. I wanted to go back to make sure, I'm not going to make any assumptions here of how familiar people are with legislation and what it looks like when bills are amended. And so for purposes of this bill, Section 1682, 2, on page 3, is where the amendment is that makes this version of the bill different from the prior version. So the section that is in italics, treatment and consult with your dentist or pediatrician as needed. You're further encouraged to consult with your dentist on all of the non-surgical dental treatment options available that may reduce, delay, or eliminate the need for anesthesia for surgical dental treatment prior to granting this consent. So that's the new language. The recommendation on this bill is to watch. And I'm going to move it.
I move to approve a watch position.
Burton, second. Public comment? Okay, sorry.
I just have a question. So from the staff's analysis of this bill, I didn't see any negative comment. So I'm just wondering why the staff recommended to watch and not to support? Are there other concerns that we are not aware of at this time?
I would say that this bill is a good example of how things change. This amendment was done on April 26th.
Okay.
And had it been anything that was any different from this, would we really have wanted to jump out there and take a support position? And I think that since it still needs to go to the second house,
Okay.
we still have time.
It's a moving target.
Okay. Well, excellent explanation. Thank you.
Burton,
Yes.
Chan. Chappelle Ingram, absent. Lai. Laren. Lay. McKenzie.
Yes.
Medina.
Yes.
Morrow. Olag. Pacheco. Stewart. Witcher. You. Motion passes to watch.
The next bill is Assembly Bill 2789, 89 Healthcare Practitioners Prescriptions Electronic Data Transmission. This bill on or after January 1st, 2020 would require healthcare practitioners authorized to issue prescriptions to have the capability to transmit electronic data transmission prescriptions, and would require pharmacies to have the capabilities to receive those transmissions. On or after January 1st, 2021, they would be required to, would require those healthcare practitioners to issue prescriptions as an electronic data transmission prescription unless specified exceptions were met. The bill would not require the pharmacy to verify that a written, oral, or fax prescription satisfies the specified exemptions. The bill would require the pharmacy receiving the electronic data transmission prescriptions to immediately notify the prescriber if the electronic data transmission prescriptions fails, is incomplete, or is otherwise not appropriately received. And the bill would authorize the pharmacy to transmit the prescription to another pharmacy at the request of the patient, and would make a violation of these provisions unprofessional conduct, and would subject the healthcare practitioner to discipline by the board charged with regulating his or her license. There has been a change to the bill's status as of May 10th, 2018. It passed the Assembly to the Senate, and it will be, it was sent to the Senate Business Professions and Economic Development Committee.
So staff recommendations for a watch position, I'd like to move that.
Second.
So the second was Morrow. I just wanted to comment before we take the vote that this is, I would echo your comments earlier, Dr. Morrow, about how things are changing and how society is changing. And this is certainly a good example of the future for dentistry. And it will, we'll see some components of this in another bill that we look at later on. But this echoes that need to move into the future. Is there any public comment? Okay,
Burton,
yes.
Chan. Yes. Chappelle Ingram, absent. Lai. Yes. Laren. Yes. Lay. Yes. McKenzie.
Yes.
Medina.
Yes.
Morrow. Olag? Pacheco? Stewart? Witcher? You absent? Motion passes to watch.
Okay, the next bill is Senate Bill 392. But this bill has been amended as of May 7th, 2018, and is now called the Parental Empowerment Pilot Project, and therefore no longer deals with dental board matters or things that are relevant to its licensees. So I believe we're not going to discuss it. The next bill is Senate Bill 501, Dentistry, Anesthesia, and Sedation Report. This bill would implement portions of the board's recommendations included in their pediatric anesthesia study that was provided to the legislature. This bill would change the way that the board regulates pediatric anesthesia by enhancing requirements for the administration of general anesthesia and deep sedation for patients 13 years of age and younger. This bill would also require the board to study how new policies aimed at increased safety would affect access to care. The status of this bill is that it has not moved. It's currently held in the Assembly Appropriations Committee as of September 1st, 2017.
And on this one, I believe that we last year took a watch position.
Yes.
And so because there's been no activity on this one, there's no need to have further discussion.
Okay. Senate Bill 1148, Medi-Cal Restorative Dental Services. This authorizes a Medi-Cal provider of services that includes the provision of dental restorative materials to provide for the use of silver diamine fluoride, otherwise known as SDF, as a caries arresting agent after consultation with the beneficiary, including informed consent, and as a part of a comprehensive treatment plan. There was a hearing for this bill, I believe, on May 14th, and it has been moved. It was heard by the Senate Appropriations Committee and has been moved to the suspense file as of May 14th.
we've moved to watch position on this bill. We recommend a watch position on this bill. And so I'd like to move a watch.
Second, Witcher.
Any public comment? No.
Not a comment, but a question. What, I believe you said that it had been moved to the suspense file. What does that mean?
So that's for, I'm actually going to have you explain this a
Okay.
little bit better, Ms. Byrne.
There are, some years ago, the appropriations committees set a dollar threshold for bills that would allow bills to move. So anything that was above that threshold is held in what's called a suspense file. And at some point prior to that appropriations committee deadline, they will look at all of those items on suspense, look at them in terms of whether the cost can be reduced, some look at them in terms of whether they are a priority, and then make some decision to then move them from there. Some things will move in June. Some things may not move until the last time the suspense file is looked at. This bill, and I see Mary, I don't know what issues are with this one, whether it's all financial. And I'll give her an opportunity to speak to that. But to answer that question first, does everybody understand what the suspense file is? Okay.
So Mary McCann with the California Dental Association. Yesterday, this bill was placed on the suspense file because it was given a price of approximately $12 million. We're currently in talks with both the author, Dr. Pan's office, and DHCS to see exactly how they came to that cost and whether or not we're able to work with the department to put in certain utilization controls to lower that price, whether that's population controls or limiting specific procedures that can't be done the same day SDF is applied to a tooth. But our intention is to work with those two entities, hopefully see it off suspense and see if we can change that price.
I have a question. What the reasoning why we're not looking at supporting it, is it because of the cost? Because I think that it would be a benefit for the children that are not necessarily receiving coverage.
Again, this is another bill that I see that has the potential to have further amendments. And if you support something, and that's on the record, and it changes so significantly that you can no longer support it, it's just not a good place to be in.
Okay, well, because we support it as it is right now.
Look beyond, I think my comment would be to look beyond the concept itself. Because there are a lot of things where we could say, yeah, we support this concept, but we may not support some of the components within it. So look beyond, I would say, look beyond the concept.
And that's would be in the bill language,
Right,
right?
right.
Yeah, so
And
there
that bill language is subject to a lot of
changes.
change.
Right, right. But what I'm saying is, and I understand that part, and I typically always look at the language instead of just going through the summary, because right there, it's basically what's gonna happen. But I'm curious on, when you approve something, you approve it as it is now, and then if, that's just we can do the watch, but that was just my thing. Then if we were to later retract because of further changes, then we can always make that decision without having a, I don't see it as a huge impact, but then again, you've been on the board longer to see if that does have an impact. But I'll go ahead watching, but I was just curious, the reasoning why for not the approval or support.
And a lot of times it has to do with when the changes are made and when the board could actually have a meeting to retract what they already had given. So that's, I think that most board members were looking for public protection and access to care issues, but we don't really know enough now to be able to support or oppose. That's why we're watching. If we come out early, it's in suspense. In the old days, it sort of used to be when it went to suspense, it went to die,
Yeah.
because it never came out of suspense. So on the one hand, Ms. Burton is saying conceptually, we would agree that we would try to deal with access to care issues, but at this point in the process, there's no point in us being out there to say that. In the event that there's a change, and the change happens, actually goes through the process, and the language then has been changed so much that the board would not support it, yet we haven't had a board meeting to get to it in time to say we don't support it anymore. It's just a matter of when we have our board meetings and how quickly these things go through. And, we wouldn't want to be on the support list if the language had been significantly changed. So by watching it, we're saying we are interested in this, and we'd like to see where it goes.
And I think last year before last, we put something in place where the legislative chair, in cooperation with the president and the executive officer, if something came up that changed significantly enough that we wanted to really be out there, that we have permission to do that beyond a board meeting. And then make the board aware of what we've done. So there are things in place, but right now, I think it's a little early, that we need to just look at this further. I don't know what $12 million is based on. But sometimes an author will accept things that will dilute the bill to get that cost down. And it's just too many unknowns to say right now, yes, this is absolutely something we want to do. Did I see you earlier? No? Yeah, did you come back? No.
Okay, so you've got a motion?
Yes, I have a question. At what time do we stop watching it? When do we know we're ready to vote and we think they're not going to amend it or change it?
As it goes through the committee process and as it is amended. And so it could be at a board meeting or outside of a board meeting. And there are some other things that we just won't, we may not move from that position. We may not want to outright oppose it, but we may not move from that watch position.
I just want to add a comment. Silver diamine fluoride has been around for a long time and just recently basically been repackaged and come back to life. I don't know how many private practice people use it. I don't know if pedo, I don't know if it's used a lot. So in my mind, I'm just wondering if it's a Band-Aid for access to care and doesn't really solve the problem, just from a private practice point of view. And so I don't know if people are thinking about it. Is it a viable solution? Does it really help the situation? Or is it just making people feel good about it? That's my concern.
And I
I'm going
see
to ask, because California Dental Association is here and they are the sponsors of the bill, and ask them to respond.
So the purpose of creating SDF as a Deni-Cal benefit was to create potentially an alternative treatment plan. I mean, if you have a carious lesion in a tooth, a dentist has an option in the decision of several things. They can do a filling, they can provide SDF, they can do any number of things. Applying SDF could, in some cases, mean a delay in the need for anesthesia for certain populations. It could also mean that a filling is placed on at a later date. So our intention in creating this as a benefit is to create that option. And we've been seeing that in other countries, we've been seeing that in other states. And we've been seeing that in this state as well, under commercial plans.
And it wasn't prior to this a Medi-Cal option?
No, so in Deni-Cal right now, you can use SDF, but only in preventive measures. So hygienists can apply it in that regard. What we're looking at right now is creating it as a benefit when the tooth is actually already diagnosed as a carious lesion.
Is this a covered benefit with regular insurance, dental insurance? Not
In
Medi-Cal?
in commercial insurances, but it really ranges the gamut. So, in terms of reimbursement rates and whether or not it's covered.
Well, my children had Denti-Cal, and so there's many people don't realize that there's a lot of things that are not covered, and you can't afford to go private practice. So I see as a bit when you look at certain issues that don't necessarily cover for students or children.
Right, so this is simply just creating another tool in the dentist toolbox. And we hope that this is something that we can, if we have kids that are 2 or 3 years old that are coming in with caries, we don't necessarily want to put them under anesthesia. So having this as a stopgap, and either they go in for anesthesia when they are physically able to, or that tooth falls out, and it's no longer an issue potentially, so. It can also be applied in other populations, special needs, where they might not be able to go anesthesia or a filling, or in elderly, frail populations as well.
I'd like to recognize Dr. Reggiardo. I think he has something to say.
Thank you. Paul Reggiardo, representing the California Society of Pediatric Dentistry. Let me give you some information. The bill, as we've mentioned before, is to recognize silver diamine fluoride application as a program benefit in the state Medicaid dental program. Last year, in April of 2017, the American Academy of Pediatric Dentistry surveyed all state Medicaid dental programs, and at that time, diamine fluoride, it was a benefit in 37 state programs. Since that time, it's been added to other states, so it's 40-some-odd state Medicaid dental programs now provide silver diamine fluoride as a program benefit. If that puts into context the utilization of the country and with other state Medicaid dental programs. Answering your question about commercial programs, that my experience, and I don't have statistics here exactly, but my experience is that it is increasingly a program benefit in most commercial programs. It was introduced recently, about 3 years ago. It had a CDT code that was added. Last year, what was added was to specify that it's a per-tooth application. And we're seeing now more and more commercial dental benefit programs that do provide that as a benefit. I think there's still a lot of work going on with the commercial programs as to how that benefit is recognized. There are all kinds of questions that come up. What is the frequency at which it's a recognized benefit? Is it once in a lifetime? Is it once a year? Is it 4 times a year? A lot of those decisions as to plan policies are still being developed and are changing. I sit on the American Dental Association's Committee on Code Maintenance, the CDT code maintenance, and get a lot of feedback from dental benefit carriers in this regard. I spoke this year to the American Association of Dental Consultants regarding silver diamine fluoride application, got a lot of feedback, and it is something that is recognized not just with kids, but adults also. There's a place for it, especially with the frail elderly and those individuals that are not good candidates because of age and because of health, because of reasons of disability, whether they're physical or mental, in the adult population and the population for the disabled also. So there's a lot of reason that we see to want to see this as a Medi-Cal or Medi-Cal dental program benefit. As a separate issue, if I might, Ed, for my understanding, that I do not understand why the board cannot or does not want to support a particular bill with, as you were mentioning, as it stands, the amended as of a certain date. And it's my understanding, very limited understanding, that when the bill is changed significantly and it goes to the next House or the next committee hearing, that part of the analysis of the bill that's presented to the policy committee, they go back and they check with the supporters, when the bill's been changed, are you still in support of this bill? And you have the opportunity to answer that question and say, we're supporting as amended, we have not yet the amended version, and you have an opportunity to step back from supporting the bill, not in concept. You're supporting a particular amended version. Am I incorrect in that interpretation?
One of the things that is unique about not only this board, but other boards as well, is when they meet. And our calendar is not necessarily the legislative calendar. And you've got a lot of levels of agreement that have to go into making that position. And so it's just been our policy not to support bills until we have a clear understanding of what they are. And particularly prior to a change where we couldn't do things outside a board meeting. And we can't do things outside of the number of members who can talk to each other. It's not like, something happens, you can call for a meeting of the legislative committee. That's against state law. And so it's our position to try to conduct our business within the board meetings. And if there is something that is significant that comes, and we feel that we want to move to a position, we've put some things in place to try to do that. In this particular case, and as evidenced by the fact that this bill was amended on the 10th and is held in suspense, and if that bill comes out of suspense, it will come out with significant amendments. If the sponsor of this bill is not able to convince the folks who have put a fiscal of $12 million on it, this bill is going to change. And it's just, it's not our policy to be in a place to get out in front of things. I hear what you're saying. There is that possibility, but that's not an option that I think that is available to us.
Can I add something? We do meet in August. Do you think there'll be significant changes by August if we were to bring this up and retract in case we say that we do not support or continue to support?
So we're hoping to be able to figure out or lower the price, but those might not be amendments. Those might be things that DHCS enacts with their own policy and might not be reflected in the bill. I can't speak at this point to whether or not I'll get off suspense. We're hoping for with the author and the legislature on that. If it does come off, we expect it to be significantly the same with the same intent. If there's utilization controls, that's something different, but that wouldn't change the intent of the bill.
I was just wondering if, as an option, we do meet in August, and if, I'm just putting it out there as an option, that we do meet in August, and in case we do want to go back, if we support it, that in case you do want to support it, then we can always look at it in August and make some changes then, but I'm just saying that that's an option.
And this legislation, everything you're reviewing today will be coming back in August, and yes, you would have the opportunity, if something has changed, or even if it hasn't changed, if we've gotten additional information, yes, you can, we would still have time to send a letter of support from our August meeting.
The only thing, and this is just my own personal preference, the only thing that I have kind of insisted on is if it's something that we're going to oppose, that you don't oppose it when it's been through both houses and it's gone to the government, and you've not weighed in on it before. But there is an opportunity to support. Okay. Dr. Lay?
Okay. So being a professional, a dentist who's actually using this material, I may be the only one, maybe with the exception of Dr. Rajado. There's no doubt, I have no doubt about the effectiveness of this material. I've used it in young children whom I cannot work on, without sedation. I've used it in seniors, in nursing home, in senior assisted living facilities. I've used it in special needs patient populations, such as autistic children. So the material works. I've witnessed it firsthand, the effectiveness. Now, this bill has to do with changing the scope of benefits of the Medicaid program, and California is behind, in comparison with other states. I would support the bill instead of taking a watch position. However, at this point in time, it's almost a moot point because it's in the suspense file, so it's not going anywhere. So by supporting it at this time, we're basically just taking that noble approach that, yes, we'll support the concept, but it's really not doing it. I'm hoping that in the future it will come out of suspense file so that we can take a position in supporting, the bill. But really, I'm using it. I'm teaching my students and residents to use it. I've seen the effectiveness of it in my patients. But yes, I'm willing to take the watch position is because it is in suspense file. It's not going anywhere. We're not making any difference by saying that we're supporting it or we're not we're watching it or we're opposing it. So that's my take on it.
Yeah, my comments are along the same line. What difference is us weighing in going to make on the outcome? It's not directly related to board operations. It's a benefit question that we typically don't get into. Now, it is an access issue, I grant you that. So, us sign support is really at this point kind of a feel-good measure, which we all like, but it's not. I'm not sure it's really going to do anything.
Our primary reason to exist is, number one, stop disease. It does not restore function. So that doesn't get to the second part of it. And we realize that we're in the gamesmanship of this bill, not the content, not the spirit of the bill. I'm more supportive of a statement that we are protecting the public by trying to stop the disease.
Okay. I'm looking at the calendar, and June 29th is the last day for policy committees to hear and report any fiscal bills. And so it could be heard by June 29th or prior, or it could be one of those bills that gets held and then you go through a series of rule waivers to get it out before the end of the year. So we've got time on this, folks. And so I'm going to go back to my recommendation of a watch position. And I'm going to allow a question if it's short. Please. Okay.
Thank you. Dr. Guy Atchison, Academy of General Dentistry. I would really hope that this is one item that the board would take a support position on, even if it's stuck and going to die in suspense, because it shows a position. And I treat special needs patients, I treat geriatrics, I take patients to the hospital that are really too sick to take to the hospital, but there's no other alternative now to try and get control of active caries, especially root decay. So to take a support position on really what is the best management tool that we have for people that are too sick and frail for me to take to the hospital, I think is important. I urge that you really consider having a statement of support.
Okay. I think that what we are hearing is that leaning toward that direction. However, at this time, I'm going to move the watch position.
I'll second that.
No, we had a second by Morrow.
Oh, I'm sorry.
No, it's by Dr.
Okay. Oh, okay. Okay, call for the question.
Okay. Burton,
Yes.
Chan. No. Chappelle Ingram, absent. Lai,
Yes.
Laren. Lay. McKenzie.
Yes.
Medina. Okay, Morrow.
Yes.
Olag. Pacheco. Stewart.
Yes.
Witcher.
Yes.
You absent. Motion passes
What was the vote?
to 4
Okay.
with 2 absent.
Okay, thank you.
Do you want to keep going? Okay, the next bill is Senate Bill 1238. It's Patients' Records Maintenance and Storage. This bill would require a physician, a surgeon, dentist, psychologists, optometrists, chiropractors, marriage and family therapists, and a multitude of other professions to provide patients with a statement regarding their right to inspect and obtain copies of their medical record and the intended retention period for the records. This bill would also require these healthcare providers to notify a patient at least 60 days before their records would be destroyed. Although the bill status is still the same, there has been a hearing set for the Senate Committee as of for May 22nd, 2018.
In your analysis, could you talk a little bit about that second sentence
Within the, or with,
in the analysis part?
if necessary, to further clarify that part?
So we would need to update.
If we felt that it was not clear enough, we could update our regulations under unprofessional conduct to explain that failure to comply with this would be considered unprofessional conduct. But it's only if on its face the statute was not clear enough.
The statute doesn't currently call.
Let me see one more time.
It says
Um,
it,
Under I, it as provider who violates the section may be cited and assessed an administrative penalty in accordance with section 125.9 of the Business and Profession Code. So it doesn't specifically call it unprofessional conduct, but if we needed to clarify to just cite this section, we could within unprofessional conduct under regulations.
I don't think that's where I would look to our enforcement people for an interpretation of that.
Okay.
You can do a cite or you can do a fine, but it may not be deemed as unprofessional conduct. Am I right? Yes. I'm sorry.
Carlos, would you mind coming up to the front?
Oops, is it on?
Yeah, it's on.
Oh, it's on. Hi, Carlos Alvarez, Enforcement Chief. Then, it would have to, well, I'm not saying they would have to, but if it would be unprofessional conduct for not notifying patients with 60 days, then that could be added there, or it could be referred to the Health and Safety Code.
Through the chair.
Yeah.
So I think it would need to be added under 1682, wouldn't it? To be unprofessional conduct, that's things live.
And that, but this one just strictly is for patient records.
Yeah,
Correct.
but to be unprofessional conduct, that's,
It'll be
yeah.
under 1680.
Or 1680, or one of those sections. Yeah,
Unprofessional
there's a-
conduct.
Yeah.
And then, yes, and that, we could use 1680 for that subsection and to, like I said, citation, if there's a violation of that.
If I could just bring this back around, first off, we really don't have any substantial issues with people destroying records. Our issues may be a little different. So while this is an interesting discussion we're having, that it's really going to affect the dental board. And that's predominantly why we say watch. We'll see what this turns into. But it's looking like from the supporters that it's a different group of people altogether that are, and I don't know what the circumstances are that people would be getting rid of records. The board has purposely not taken a position, if you will, on how long dental records need to be held by dentists, because we've relied essentially on their legal representation, their individual representation, to help them determine that, along with reviewing what their insurance carrier recommends. So the board has not been in the position to recommend any length of time for records to be held. And as I've said initially, we haven't. The issues we have surrounding dental records aren't that the dental records have been destroyed. If we have issues, it may be that licensees are not as forthcoming with giving copies of their records to their patient. So this one, I think, would have minimal impact. I don't think on the road of discussing if it came into being where it would be, whether it be unprofessional conduct or where it would land. But as this goes through the process, we may get more information. But at this point, it really doesn't affect how we do business. I just would, I'm not trying to shorten this conversation, but I think we're going to have to get a lunch break here, because I'm seeing that people's concentration level is waning, if it hasn't already completely gone. And so we're cutting to the chase on this one.
Did you have a comment, Tony? No? Okay.
Sorry.
Position on this is watch. Is there a motion? Move Chan. Medina, second. Any public comment? Go for the question.
Burton,
Aye.
Chan.
Aye.
Chappelle Ingram, absent. Lai?
Yes.
Laren? Lay? McKenzie?
Yes.
Medina?
Yes.
Morrow? Olag? Pacheco? Stewart? Witcher? You is absent. So the motion to maintain the watch position, it passes.
Okay. We're getting close.
Senate Bill 1298, increasing access to employment act. So this bill prohibits the Department of Justice from releasing the record of convictions that were dismissed pursuant to specified provisions. This bill also requires that only convictions from the prior 7 years or for which the person was incarcerated, on probation, or parole within 7 years of the request. This bill would require the Department of Justice to furnish a copy of the criminal offender record information, otherwise known as CORI, to the subject of the request, and require the Department of Justice to allow the subject a reasonable opportunity of not less than 5 days to challenge the accuracy or completeness of any matter contained in prior to furnishing a report to a third party. The bill would require the Department of Justice to make specified corrections prior to furnishing the information to the requester.
Okay, this is not similar, but the same reasons that I think that we need to watch this and not support this has to do with the kinds of things that we would do discipline on in protecting the. I'm going to move a watch position. Second, Chan. Any public comment? Questions from board members? The question? Aye.
Chan? Chappelle Ingram, absent. Lai?
Yes.
Laren? Lay? McKenzie?
Yes.
Medina?
Yes.
Morrow? Olag? Pacheco? Stewart?
Yes.
Witcher? You is absent. The motion to maintain the watch position has passed.
It's in the bill 1482.
Yes, Senate Bill 1482, dental is also one of the copies that Jerry passed out. We have an updated version as of May 2nd, 2018. This bill would remove the Dental Hygiene Committee from the jurisdiction of the Dental Board and continue the Dental Hygiene Committee of California by creating the Dental Hygiene Board of California within the department. The bill would change the manner of appointment of the Hygiene Board by requiring one public member to be appointed by the Senate Committee on Rules and one public member to be appointed by the Speaker of the Assembly rather than the Governor. The bill would extend the repeal date of the Hygiene Board and related appointment provisions to January 1st, 2023, and would board to appoint an executive officer. The bill would require an out-of-state applicant or licensee to instead furnish a hard copy of fingerprints if electronic fingerprint images don't exist. The bill would also delete the requirement that the committee make a determination and would require the Hygiene Board to conduct random audits of licensees in compliance with the continuing education requirements. Additionally, the bill would require within the preceding 5 years satisfactory completion of the dental hygiene exam given by REB or any other clinical or dental hygiene examination approved by the Hygiene Board. The bill would require the Hygiene Board to renew educational programs for dental hygienists and authorize the Hygiene Board to place a non-compliant educational program on probation, issue a citation and fine, or have its approval withdrawn. The bill would also specify limitations for fees and limit the fee for a site evaluation for dental hygienist educational accredited to no more than $2,100.
Okay, this bill was amended. Members, if you look at page 3, the amendment is in section 1901, the Business and Professions Code. 1901.5, which basically allows for appointment of a CEA as executive officer. I would, this is different from the last time dental hygiene went through. And I know that we had some questions and concerns the last time. And so before we move a motion on this, I'd like to ask if any members have any comments. Whoa, okay. So the staff recommendation is to take a watch position on this bill.
Correct.
And I'm going to move that watch. Move Burton, second Chan. Any public comment? The vote?
So Tony, they just forgot to put your position in the bill in the first place?
So it had to be amended to include me,
Okay,
which is nice. I appreciate
that's
that.
very nice, yes.
Burton,
Yes.
Chan,
Yes.
Chappelle Ingram absent, Lai,
Yes.
Lay, McKenzie,
Yes.
Medina,
Yes.
Morrow,
Yes.
Olak, Pacheco, Stewart,
Yes.
Witcher. You is absent, then, to maintain a watch position passes.
Sorry, Mary, I didn't ask for public comment.
No, you did. I'm just coming up for the next bill.
Okay.
Okay, last bill on the agenda, for this portion at least. Senate Bill 1491, Healing Arts. This non-controversial cleanup language as proposed by the board. Additionally, other non-controversial cleanup language is included for other healing arts boards. Amendments have been made to the bill regarding other healing arts boards issued. I did want to note that the bill status has changed. As of May 14th, it's moved from the Senate Appropriations Committee to second reading without hearing pursuant to Senate Rule 28.8 and to consent calendar. For those who don't know what Senate Rule 28.8 is, I will read to you what that means. It's any bill referred to the Senate Appropriations Committee pursuant to Joint Rule 10.5 that does money may not be set for hearing and shall, along with any non-substantive amendments, promptly be reported to the Senate with the recommendation that it be placed on second reading. If the chair of the committee determines that any additional state costs are not significant and do not and will not require the appropriations of additional state funds, and the bill will cause no sense in revenue.
Because this is language, omnibus language that was approved. In the past, what we have done is to take a support position only on that section of the bill that pertains to us. Can I ask why you wanted a watch position this time?
I believe when we completed the legislative analysis, at the time, we had not, because we did send that letter, why we're registered as the dental board as registered support. But I believe at the time when the analysis was completed, it was watch, and it was before we had sent out the letter of support. But I think support would be sufficient, given the fact that we did already send that letter.
We don't need to go back to watch it.
Right. So,
Okay.
yeah, we could, instead of it being watched,
Okay.
probably support would be the more appropriate recommendation as of now.
Support that section that pertains to us. And since we've already made that motion and sent the letter, then we don't need to do anything new on this bill.
I'm sorry, go ahead.
I'm sorry, did you say that this has been recently amended
No.
since April 2nd?
No, it hadn't amended, but I believe at the time when it was introduced, we had not taken a position on it, but we did send that letter shortly after. So I just didn't know we need to put on the record that we are officially supporting since we already sent that letter. Whatever you think is best, I'm sorry.
I think we've supported it.
We supported it.
Correct.
We supported that section that pertains to us.
Correct.
I'm curious, since you mentioned that, did us, the board, support it after the fact? Or was it?
No.
It's
The
introduced.
omnibus bill is an opportunity regulations, and it's an opportunity that for years, the Business and Professions Committee has given to boards. It's using non-controversial language, and so we submitted some language of our own, and we sent a letter saying, thank you for doing this, and we support you doing this for us. And so only that section and not the entire bill.
But that was with this board, right?
Yes.
Sent
This
that.
board approved that language at the last meeting last year.
Okay, okay,
So that language was put into this bill.
okay.
Okay?
So since we are not going to do anything new, is there public comment?
Yes, Mary, CDA. I just want to let you guys know that there's going to be a new amendment to this bill that will be amending the language that initially we were under AB 1277. For those of you who don't remember, that is the water line bill. We are going to be amending it and putting it under unprofessional conduct and retracting what was passed last year to amend what the board initially adopted as the regulatory language. So the amendment that we made with the dental board legal staff and DCA legal staff, and found that just amending the statute rather than a regulation would probably be the most efficient use of everyone's time. Once that is amended and once this omnibus bill is passed, that would effectively negate the need for the regulatory initiated at the last dental board meeting. So Karen can speak more to that if she wants to about what that process would look like. But just to refresh everyone's memories, the specific language was really a change of 2 words so that the focus of what antibacterial or antimicrobial properties that would be during procedures on exposed dental pulp rather than procedures that expose dental pulp in general. That way, there'd be less of a liability and it'd be more targeted towards the actual problem that we think came out of the tragic Anaheim incidences 2 years ago now.
Well, hand it off to Sarah since we haven't heard from you for a while.
I'm still over here. So, just to clarify for the newer board members, last year there was a bill, AB 1277, that was enacted the board to promulgate emergency regulations that would specifically require water or other methods used for irrigation to be sterile or contain recognized disinfecting or antibacterial properties when performing dental procedures. The key point to this is when procedures that expose dental pulp. And so the board staff had drafted regulatory language and brought it forth before the board at the November meeting. At that time, CDA had offered up an amendment that rather than when performing dental procedures that expose dental pulp, it was when performing procedures on exposed dental pulp. The board had approved that regulatory language and we submitted the emergency rulemaking package to DCA for approval. And there was questions as to whether or not we had the authority to do that because it deviated slightly from the statutory language. And so the outcome of that discussion was that no, we didn't have the authority that we needed to adopt what was specifically taken out of statute. And so we came back at the February board meeting and made that amendment, and we went through, we're going through that current emergency rulemaking process right now. CDA has maintained that it needs to be on when performing exposed dental pulp. And so the only solution to this problem is to find a statutory amendment. So From a technical standpoint, what this amendment will do is it will put that specific language in our unprofessional conduct and give the board the authority to, when we perform inspections or investigations, if there's a violation of that language, then it's wrapped up into our unprofessional conduct and part of our disciplinary proceeding, rather than mandating the board have to amend its minimum standards for infection control, include that language in it, and then it becomes effective. So this is a more expeditious route. Understanding when this is amended, it will also repeal section 1601.6, which had put in the requirement for the emergency regulations. So while we're still promulgating the emergency regs to maintain compliance with the current statute, if this becomes effective, then we will just cease working on that project. That's where we are right now.
That's just for informational purposes, and you don't have to do anything with it right now.
The board had initially supported that language at the November meeting. And then the board had to go back and reapprove the language to match it back to statutory language.
Thank you, Fran. I think we can all agree it's time for lunch. How about 2 o'clock? Is an hour good enough? 2 o'clock. Be back. Thanks. What we're going to do is go to agenda item number 11, and then we're going to skip to number 14. So with your permission, that's what we're going to do. And so item 11 is a discussion on possible action regarding status of 2-year provisional approval of the State University of Medicine and Pharmacy Nicolae Testamenitanu of the Republic of Moldova's Faculty School of Dentistry School's response to deficiencies outlined by the Dental Board of California.
So if board members want to find agenda item 11, we've been working closely with the school, the dental school in Moldova. They have responded very quickly to the board's request for additional information in order to complete their deficiencies. At this point, I'm going to hand it over to Dr. Morrow, who is the lead on the site visit team, and he's been working closely with the other 2 members of the team, and he will be giving his report.
Thank you very much. It's a good opportunity to be able to finalize the application and the approval process for the State University of Medicine and Pharmacy in the Republic of Moldova. As you recall, almost a year and a half ago now, close to 2 years ago, the site visit team recommended and the board approved a provisional approval for the school in Moldova. And that provisional approval was based on some deficiencies that we felt were correctable, and we requested some additional documentation to support compliance with a couple of the institutional standards that we had some concern about. The major one of those was actually standard 1024 C6 and 8. They had to do with competencies for graduating students who would be competent. Our standards identify 14 areas of dentistry that the graduates need to be competent in upon graduation. And it is the institution's responsibility to provide documentation to support that their graduates are in fact competent in those 14 areas of treatment. Over a period of a number of months, we have been working with the institution to provide us with that documentation. And The site visit team, consisting of Dr. Tim Martinez and Dr. Octavia Plesh and myself, have been working together with board staff to accomplish the task. And it is our recommendation at this point that the University of Moldova has provided us with sufficient documentation to support that the graduates from their program, or dental education program, meet all of the standards that are identified in regulations, Standard 1024. And it is our recommendation at this point that the board grant full approval to the dental school at the Republic of Moldova for a 7-year period. Approval is for a 7-year period, at which time the institution needs to apply for reapproval, and it has to be, that application has to be received prior to 7 years of their completion of their original approval. So it is my pleasure to recommend to the board that we grant full approval of this dental school at the State University of Medicine and Pharmacy of the Republic of Moldova for full board approval. That's a motion.
Do we have a second? Discussion? Dr. Lay?
Just for clarification, the 7-year period that you mentioned, Dr. Morrow, does that start today, or does it actually begin at the time that we provided the school the provisional acceptance?
To our legal counsel.
It would be effective the day it was approved, so it's not from today's decision, it was when it was approved first.
Okay.
So it's running right now.
Further discussion? Public comment?
So let's just clarify, because I'm getting a lot of strange looks. So the provisional approval, the 2-year provisional approval would be effective through December of this year. But because the board today granted full approval, Michael, did you just say full approval becomes effective today? Awesome. Thank you. Just wanted to clarify that.
So then the 7-year clock begins today, is that right, Michael? It began in December of? Okay, got it.
That was my question.
Okay, so just to clarify, the question was, because the university had already received provisional approval, does the 7-year clock start then or now? And it started then.
Dr. Witcher?
For the benefit of the newer members on the board, could you maybe say a few words about what the last required documentation was and what it consisted of? In other words, it was core competencies, but what was the sample and so on?
The request was, and the site visit team has the authority to request additional documentation to support compliance with the standards for the educational institution. We requested documentation to support compliance with the identified 14 competencies, which was provided to us over a period of a year plus. Part of that length of time was, I think, with a difference in language barriers and understanding what we were asking for was not what we were receiving. So we worked with the school and with the faculty there to obtain the information that we were wanting. Basically, competency, The definition of competency as far as dental education is concerned is the knowledge, skills, and values that are necessary to enter into the practice of general dentistry. These 14 competencies were areas that were specifically required to document that their graduates had that knowledge, those skills, and those values to enter into the unsupervised practice of dentistry, not as a student under the authority of an attending faculty, but as a practicing dentist. The competency assessments and examinations are standalone evaluation or assessment of a student's ability to provide care to a patient under faculty supervision, but without faculty intervention, unless the patient is endangered, unless the attending faculty feels that the patient is in some state of danger as a result of what's going on. So these are assessment forms that we asked for sample of. The board staff randomly selected a 10% sample of the recent graduating classes from a roster of students that had graduated. So we selected randomly a 10% sample of those students, and then we asked for the actual copies of the assessment documentation that was used to assess competency of these 10% sample of students in all 14 of those competency requirements. And it took us some number of months and some submissions of documents to meet our satisfaction that we had the proper documents and that they did in fact assess competency of those randomly selected students. Does that help?
Yes.
Okay. See that dental education in the United States is basically governed by the Commission on Dental Accreditation, and that commission has standards, educational standards, that schools in the United States must meet in order to maintain their accreditation. And we basically followed the same format and the same process of addressing applicants from foreign dental schools to meet the requirements that we have in our standards. Now, unfortunately, and I'll take the opportunity to mention this, unless legal tells me I'm out of line, and that is that our standards and regulations for the dental board are not the same now as CODA standards are for the United States schools. Now, they were at the time that these regulations were written, but CODA's standards of educational in the United States have changed since this, but we have not changed ours. So I think it is imperative on us that we update our standards, educational standards, when it comes to assessing foreign dental schools. Because we need to have standards that are equivalent to the standards of CODA, the Commission on Dental Accreditation, for U.S. dental schools. And our standards at this point in time are not consistent with those for dental schools in the United States.
Thank you, Dr. Morrow. Dr. Witcher?
Just if no one else has questions, I have a follow-on question. If anybody else has anything, jump in.
Go ahead.
Yeah, I would just ask, maybe for the benefit of the newer members, what assurances it seemed like the university struggled a bit to come up with the documentation for the competencies, like it was a new process for them that they had not been previously using. What assurances do we have that this is going to remain in place and that it will be used for the next 5 to 7 years?
I believe that we have the authority to ask for and do periodic evaluations or assessments during the 7-year period when the school has an approved status. And it would be incumbent upon us, I believe, to assess the school on an ongoing basis to make sure that compliance is remained. But to a certain extent, Commission on Dental Accreditation only approves institutions in the United States on a 7-year basis as well.
I understand.
So that's
there's
standard for the
yeah.
industry.
Any further questions?
Yes, I have
Dr. Lay.
a follow-up question. So, our legal counsel said that the approval date will date back to December 6, 2016. So what that means that the graduates of the school after December 6, 2016 will be eligible to sit for the RAB and apply for a California license? Correct?
They have been eligible since they got their provisional
since the date.
approval.
Okay, all right.
Is that your question? Is that the answer to
That
your
was
question?
my question, yeah.
Seeing no further questions. Oh, Dr. Witcher.
Before we get to a motion, I guess I would just feel, I mean, I wouldn't want to treat one school differently from another. But being that this is a new school and a very long way away where we might not have the feedback that we would get if it were within California, I would feel more comfortable if we had some plan as to maybe how we would follow on with additional requests for information. I mean, if there were just maybe a committee or subcommittee or some entity that would meet and discuss that with the school or something. I mean, I don't know that we have the authority to do that, but I would feel more comfortable, I guess, if I knew that there was going to be some monitoring.
Well, and it's my opinion that that would be up to the board president and executive officers down the road from a standpoint of, do we want to initiate a reassessment of the school, which we have the authority to do. I will add one more thing. When the code was written and the regulations written for the Dental Board of California to approve, to process applications and to approve foreign dental schools, there was no process in operation at that time to make this happen other than for the dental board to do it. Since then, the Commission on Dental Accreditation has established a process for accreditation of foreign dental schools, utilizing the same standards, educational standards, and the same process that is used for U.S. dental schools. I think it would behoove us as the dental board to look into legislation that would allow the dental board to, what should I say, to accept the assessment of the Commission on Dental Accreditation in their foreign dental school assessment now, instead of the dental board being in the business of approving foreign dental schools. I'm not sure that the dental board is utilizing its resources, its time, and its energy to its best advantage with processing and approving of foreign dental schools when the Commission on Dental Accreditation now has that process available. There is one foreign dental school right now that is in the terminal stages of that process. And when and if that occurs, that will be the first foreign dental school that the Commission on Dental Accreditation has approved. And if they approve that, or when they approve that, that graduates from that school will be eligible to practice in all 50 of the states. Where a school that is a foreign dental school that is approved by California, they are only eligible to get a license in California through that process. So it would be through the advantage of foreign dental schools to go through the Commission on Dental Accreditation process rather than through the dental board, and it would take the dental board out of the arena of assessing and approving foreign dental schools.
Yeah. So, I guess this is another follow-up question. When we approved the other foreign dental school, as I understand, a year or two later, they started an international dental program without notifying the board. And I understand that when we approve the school, we approve the school, we don't approve programs. So I'm just wondering what's gonna happen if the school decides to open an international dental program. is this board going to require any sort of notification or any sort of reviewing of the International Dental Program curriculum?
Can I respond to that? Okay. California Code of Regulations, Section 1024.8, notification of change required for foreign dental schools states, an approved institution shall notify the board in writing no later than 30 days after making any change in the following: location, mission, purpose, or objectives, change of name, shift or change in control of the organization. In my opinion, if the school initiates a different program, like an international dentistry program, that is a change in mission, purpose, and objectives, so therefore, they must notify the board that within 30 days of making that change, and the board then has the authority and the responsibility to assess that change and to see whether it continues to meet with the educational standards as a result of that change.
I hope that will happen because I know it didn't happen with the last one. So that's why I brought up the question. Thank you.
And for those of you that might not know, at this point, as of today, there are only 2 foreign dental schools that have ever been approved by the dental board. This one in Moldova is the second one. So in all the years, we've only had 2 successful applicants for approval in this process.
All right, I think we have a motion on the floor. Do we have a second?
Yes, we do.
And have we had public comment?
Dr. Guy Atchison, Academy of General Dentistry. To answer your question, the University of Moldova has had a website up and running for at least a year and a half, advertising directly to Californians that they can attend that school and only need a high school graduation certificate as a basic application standard. So they are marketing directly as an international program.
Senator Blanco, welcome.
Thank you, Mr. President, members. I'm here today to give thanks and acknowledgement to the work that has been done over the last year and a half, almost 2 years. Want to give special acknowledgement to the site team, Dr. Morrow and the team. We believe that the legislature, when it established the rules and regulations, were very clear and precise as to addressing the protections that were needed for public safety, the competency levels that were established, the standards. We're very excited to learn of the recommendation today. As to the modifications of the mission or the change, we will adhere to that. That is an existing statute, I believe, or rule. This is an opportunity, once again, to allow for what we view as quality of education to California standards, in lieu of lowering standards for foreign-trained dentists, which was the public policy consideration when this particular bill became law. It created a process that had buy-in from the California Dental Association, buy-in from every dental society, including the sponsors of the bill. And so we have today a mechanism that brings quality of education with competency levels and the necessary performance and protections to ensure that that individual who graduates from this university has met those particular competency standards and can, in fact, come and take the exam in California. And if successful, then they get licensed. And we are very excited about the recommendation, and we would humbly ask for the support of this body. We believe it meets the four corners of what the legislation calls for, the rules and regulations and the standards, in addition to the protections to the public. Thank you very, very much on behalf of the university, its rector, the faculty, and the students.
Thank you, Senator.
If I can, President Stewart, I would, especially the new members of the board, I would like to make sure that you understand that graduating from a dental board approved dental school does not, in and of itself, provide licensure to practice dentistry in California. All it satisfies is that the applicant has graduated from a board-approved dental school. Still requires taking and passing the written National Dental Board examinations, which is what graduates from U.S. dental schools have to do in order to get a license. It also requires taking and passing the REB clinical examination, which other graduates from dental schools have to take. It also requires taking and passing our law and ethics exam, meeting all the other requirements for licensure in California. The only component of licensure that it satisfies is the educational requirement. So just because they've graduated from that school does not mean that they're going to get a license to practice dentistry in California, only that they have graduated from a board-approved dental school.
Thank you, Dr. Morrow.
I'd also like to address Dr. Atchison's comment about the admissions policy. In our CCNRs, it does allow that option to the schools, but the requirement is that the institution shall have and shall follow specific written criteria, policies, and administrative procedures for student admissions. The institution shall not admit any student who is obviously unqualified or who does not appear to have sufficient pre-professional education in basic sciences to complete the professional program. We've heard often that people are concerned that students can go there out of high school. That's not the American model. However, it can be construed to be the European model. So the site team did take that into consideration as they reviewed all the curriculum. And again, if we receive a complaint somehow that if somebody is licensed in the state of California after having passed the national exam and the REB, I mean, this requirement only means they've met the educational requirements. Okay.
Also, if I could add, the dental school curriculum at the university in Moldova is a 5-year curriculum. Dental schools in the United States are 4 years, with the exception of the University of Pacific in San Francisco, which is 3 years. So when you say they accept students out of high school, their high school curriculum is not the same as our high school curriculum here, number one. And number two, their dental curriculum is 5 years instead of 4. So they are not necessarily completing their dental education with less foundational background than students in the United States are. All dental schools in the United States do not require a college degree for entrance. Most of our students do because it's a competition type of a situation. But dental schools in the United States require certain curricula, certain courses that are required, but not necessarily a degree. So looking at the high school education equivalent in European countries, the fact that their dental education is 5 years instead of 4 pretty much balances out the amount of educational experience that they receive in getting their degree.
Hi, This is Dr. Zhongwei Chen. I'm the program director of Loma Linda Pediatric Dentistry Program. I'm a full-time educator, and I'm also the foreign educated dentist. So if you're going to compare different kind of school, I will not say the quality is not. I want the board to reconsider. I want to echo Dr. Morrow's comments that CODA is the one that's supposed to be really putting the effort into the education accreditation. When the board is putting more time and effort to do the education accreditation, that we maybe need to reconsider. The second thing is, my student graduate hard to find a job in Southern California. The working force, when we are having another school which is international, the language is not exactly the same. And we are opening more working opportunity for them. Why don't we open some working opportunity for someone, for example, Hispanic group, or whichever language group which is easier. So for my student, I would say like the student go out right now, it's hard to find a job, and then it's very competitive. So I want to urge the board to think, of course, I'm not trying to stop the school for being passed or anything, just reconsider the role and position of the board in trying to accredit the other dental school. That's the first thing. And then it's to consider the workforce. Thank you very much.
Thank you for those comments. Any further comments?
Just for clarification, the dental board does not accredit foreign dental schools. We just approve them for California licensure. So they're not accredited as if they would be from a national accrediting organization.
Thank you. Thank you, Maureen Titus. I'm speaking as an individual, not as from a group or anything. Just looking, as has already been stated, about the requirements of attending the school, it's much easier to get into that school, obviously, than it is to one of our California schools. So my concern is we're talking about all the requirements and everything taken, but we've never talked about what is this going to do for California? How is this going to benefit the consumers of California? Is this going to help the access to care issue? Is this going to help the public and safety issues? So that is part of my concern. Also, I am also concerned about the fact that the previous speaker just mentioned about competition with our California graduates maybe having problems. Are there going to be a big influx of students from that school coming here to apply for positions in California? So my focus is on the health and safety of the consumers of California, and how is this going to benefit California? I've never been clear in the 2 years, or almost 2 years I've been coming here, about why this was even brought forward, why this school from this particular area. I did understand the one down in Mexico, because there was a talk of that time, but helped to access to care for that population of people, the Hispanic population we have in California. So anyway, so all questions, and not to be so negative about it, but are just things that all of a sudden come to my mind. Are we talking about this, or are we not talking about this? So I just want to make a couple comments. Thank you.
Thank you for those comments. Any further comments from the public? Seeing none, I think we're ready for the vote.
Burton. Chan. Chappelle Ingram, absent. Lai. Laren. Yes. Lay. No. McKenzie.
Yes.
Medina.
Yes.
Morrow.
Yes.
Olag. Pacheco. Stewart. Witcher. And you absent. The vote was 9 for aye, 1 for nay, and 2 for abstain, and 2 absent. The motion passes.
Thank you. Dr. Morrow and your team, thank you for all that hard work, and it was just a job well done, and all I can say is thank you.
Well, thanks, and neither one of them were able to attend this meeting today, but Dr. Martinez and Dr. Plesh have contributed immensely to this effort, and I am indebted to them, and I think the board is indebted to them for their contribution, for their tireless efforts in this process. This has been a long, lengthy process, and it has come to a conclusion. And that's the best part of it, is that it's come to a conclusion.
All right, we're now moving on to agenda item 14. The subject is presentation regarding dental anesthesia data collection tool.
Oh.
Sorry.
Dr. Kaplan, if you'd like to start this off and just explain what you're going to be talking about today, and then go ahead and introduce the people you've brought with you. And then when it comes time for you to do your presentation, we'll just give the board members an opportunity to step to the side so that they can view it. Okay.
Does she know the time limits?
Oh, yeah. So we've set aside 20 minutes for the presentation, and then 20 minutes for questions and answers after that. So we'll be timing. We bought this clock, but it's like this big. And we didn't want to bring it on the plane, so.
We wanted to show this, it's okay.
We'll be letting you know when you're down to 5 minutes for the presentation, okay?
Okay. Hi, hello, thank you so much for making.
And you need to use the mic
Oh,
because they
this-
can't hear you.
Sorry.
So.
It's on.
It's on.
It's on.
Okay. Are you ready to show? Oh, okay.
Okay, we need to.
Hi, everyone. My name is Dr. Anna Kaplan. Thank you so much for making the time today. For the past 2 years, I've been advocating for improved safety for the children undergoing sedation in dentistry. And we all know sedation is practiced very differently across different disciplines, and with everyone having the same goal of safety. Today I'm here, I was going to go down to this slide. Today I'm here to talk about the opportunity for the California Dental Board to take proven steps towards improved patient safety. When Caleb's Law, also known as AB 2235, was enacted, part of it had legislative intent language that I want to show. I don't know. I don't know where that's. Okay, that had legislative intent language to encourage the dental board to establish systemic data collection or quality improvement. Today, we are going to introduce you to a data tool that was put together by a nonprofit called the Pediatric Sedation Research Consortium, which is a national nonprofit that's been doing this for the past little bit over 15 years, in collaboration with the American Academy of Pediatric Dentistry. The beauty of joining forces with the nonprofit to do this work is that most of the work is already done by them, and most of the upkeep is done by them. The creation of the tool has been already done by the American Academy of Pediatric Dentistry. And the Pediatric Sedation Research Consortium will do most of the troubleshooting for IT issues. They'll be willing to do analysis if that's what the board wanted. Data auditing, things like that will be taken care of. So I'm here today to say, as a mission to promote safety must include quality improvement in order to succeed. So I'm here with an all-star team of academics across different disciplines that will explain to you what the tool is and how it works and different details about it. Thanks. Thank you so much.
Good afternoon. I want to echo Dr. Kaplan's thank you so much for hearing us out. I'm Dr. Rita Agarwal. I am an anesthesiologist who specializes in pediatrics. I'm the past chair of the American Academy of Pediatrics section on anesthesiology and pain medicine, and I'm currently a clinical professor of anesthesiology at Stanford. And I'm going to kick off our presentation. So why does this matter? Why is this important? Well, we feel very strongly that sedation is sedation is sedation, and it really doesn't matter what the procedure is that you're doing. It's all the same in terms of the medical part of sedation. Dr. Crivero, who we'll quote a few times throughout the presentation, is the founder of the group, the Pediatric Sedation Research Consortium. And when he first started thinking about this problem back in the early 2000s. He is quoted as saying, "We must all recognize that nobody owns pediatric sedation, that individuals who are trying to accomplish the same outcomes for the same patient population should share data and attempt to move towards best practices in a collaborative manner." Sorry, I thought I could get that all out in one breath, but I couldn't. So he, with a group of other people, and this is just a definition, I'm not going to go over it, of what the different kinds of sedation are based on the American Society of Anesthesiology's definitions. And they don't, the point of this is that they don't really define it based on procedure, they define it based on level of consciousness and responsiveness to stimulation. This is a report from the Dental Board from 2010, basically looking at the number of deaths. I think it's just deaths. It's not, deaths or significant complications. And the point of this slide is just to say that the problem is uncommon. We accept that, we recognize that. Obviously, nobody would be out there doing this work if this was a common problem. But it does occur, and that's the important part, is it does occur, and we don't know why. We don't know what went wrong. We don't know what we can learn from these events so that we can prevent that from happening again. We know from the medical side of the world, blame and shame don't work. We tried that. Back when I was a resident in the 1980s, it was all finger pointing and well, I won't say it, but there was a lot of blame and shame, and that doesn't work to move medicine and sedation and other practices forward. Root cause analysis can be very helpful for individual cases. So if you're within an institution, you can do that kind of stuff and figure out within your institution, how can you improve? How can you get better? How can you prevent things from happening in the future? What we need is data. We need big data in order to be able to make these decisions. This is from the Institute of Medicine's. It's the 6 domains of healthcare quality. And basically, what we're looking for is, how do we keep this safe? How do we make it effective? How do we keep it patient-centered? How we want to deliver care that's timely, efficient, and equitable across all domains. We're not focusing on all of these points right now, but we are focusing on safety. And safety is defined by the Institute of Medicine as overall mortality rates, or the percentage of patients receiving safe care, meaning patients who do not have a complication or a problem that occurs as a result of it. And the answer right now is that we don't know that. We don't know these numbers. What is the incidence of mortality or serious damage to a patient getting sedation or general anesthesia for dental work? It's a huge question mark. None of us knows the answer to this question. There's the study that was quoted from the oral surgery literature that states it as perhaps 1 in about 350,000. It's an estimate based on best available data. There's the Pediatric Sedation Research Consortium data that has reported so far no deaths or serious neurologic injuries in over 500,000 sedation encounters from a variety of places and practices. And Wake Up Safe is a pediatric anesthesia data gathering base that has looked at participating institutions, all of their patients, and they have had, again, 0 deaths or serious neurologic injuries in patients undergoing general anesthesia who are otherwise healthy from an anesthesia cause. So can we do better? We don't know, because we don't know what we're benchmarking right now. Again, this is just a little bit more detail on that. Pediatric Sedation Research Consortium, no deaths in over 500,000. Wake Up Safe, no deaths or neurologic injury related to anesthesia in almost 2 million healthy children. There were complications, and the complication rates were around, depending on the study and the location, but approximately 10% or so. So 1 in 10, that's not insignificant. But none of them led to severe or permanent injury. And anesthesiologists have been really systemically and systematically trying to study this, near misses, adverse events, and complications for years. We've made this our life's work to try and make what we do safer. A couple more words about the Pediatric Sedation Research Consortium. First of all, I just want to be very clear. I am not a member of the group, and I have really, other than Dr. Carvero being a friend and a colleague, I really have no skin in the game of this particular group. But it's a collaborative group. It's institutions and practices dedicated to improving sedation, and it's a variety of practitioner types that are involved with this group. They look at prospective observational outcome data for all of their patients undergoing procedural sedation. The thought being that it's critical to continue to develop and to improve safety is you've got to know what you're dealing with. So this is a quote from Jason Reynolds at the very bottom. He's currently the president of the Society of Pediatric Sedation, which is a group that grew out of the consortium, that our visionary founders were able to see that sedation did not belong to any one specialty or practitioner. They understood that progress in the field would be best enabled by breaking down those barriers and working as a multidisciplinary and multi-specialty group. These are, I'm not going to go through these. We can send you copies of the slides if you're interested at a later date, but this is the very, very initial group of people who met to talk about it. This is just a snapshot from their website for anyone who's interested in finding out more about the group. They can go to the website and take a look and see what they're doing. You can see there's ongoing research, there's ongoing projects, there's ongoing a lot of different things and guidelines that are being set up. This is the mission statement from the Society of Pediatric Sedation, that they are striving to be the international multidisciplinary leader in the advancement of pediatric sedation by promoting high-quality, safe, innovative research and professional care in children. Again, we want to be the leaders in this. We want you to be the leaders in this, and this is really what we're trying to present. This is just to show that there's ongoing QI efforts continually through this group and through the Society for Pediatric Sedation. So what we know right now is we need data. We want to know what we're trying to accomplish. The accomplishment is not just change for change's sake, but how to make that change an actual improvement, and what changes can we make that will result in that. And I'm going to turn the microphone over to Dr. Chen.
Thank you. So this is Anna Chen from Loma Linda, and I'm a pediatric dentistry program director and represent the AAPD. AAPD has been the leaders in the oral sedation and pediatric sedation. AAPD's record has been used for years. This is our sedation record, and you can see there's a lot of information. There's totally front and back 2 pages. This is available online. So if you would like to have the references, you can have the copy of this to see what are the information that we usually ask if anyone perform any kind of sedation, what kind of data we suggest to have. AAPD have already working with the PSRC to develop a web-based data entry, which is there is a database that have already been started. There are 6 institutions nationwide, which is not only in California. There are Loma Linda, Harvard, UT San Antonio, University of Washington, Cincinnati, Children's Hospital, Indiana. So you can see it's all nationwide, and we're trying to do this pilot study to collect the data because we want to know, is this safe too? AAPD would like to know how to practice safely. So all these data were collected in this, and this is the demonstration. This is a screenshot of those, and I know this projector cannot see very clearly, so we are going to take a look of demonstration. I'm going to demonstration to you. This is a live. This is a web page that is showing you right now, and you can see how to enter this form. It's a very easy to use web-based, so as long as you have any internet connection, you can enter anywhere. So you can pick, you have to pick on each one of it, and then you can enter the data. Is that means I'm done? No. Okay.
It's just someone's phone.
Okay. So this is, you can take a look. It's a very simple, and then this is 5 page of the form. So I'm trying to show you how easy it is, and then the whole thing go through is less than 3 minutes. But you have to enter each one. For example, if you just say, oh, I forgot which operator I'm going to check, and then I'm going to hit continue, it will say, please enter who is the one who do it. So it's make sure you have all the data collected. And also you can see all the information. There's no information of the patient health information be identified. So I'm going to go back to our presentation. So this data collection is a pilot study data that has already is there, and also it's flexible, it's cheap, easy to store and access, very secure because it's been stored in the Dartmouth, and all the information is encrypted, and most of the work is done. So why not? We're here to try to propose, like, why not the board use this information?
So, sorry. Once again, the time to complete, and Dr. Chen has done this, it's less than 3 minutes per patient, and this is the AAPD tool, which can be used or which can be modified for use for California, and it can be completed by anyone on the dental care team. So it does not have to be the dentist, it does not have to be the sedationist, it can be anyone who's designated on that team. Oh, sorry. This is just from Dartmouth. This is one of their slides on how you would start a project like this, the collaborative project development. The bottom line is basically most of this has already been done. Most of this work has already been achieved. And Dartmouth Bioinformatics, the reason that it's their group is because that's where Dr. Crivero was when he started this work and has worked with them now for over 15 years on this. They will come in at any point, they'll work at any level, they will be as involved or as uninvolved as you would want them to be. So basically, this would be a little mock-up of it's all encrypted. You use web servers. They're also developing an app so it can be on a phone or an iPad to fill out. It can be on a web base. The sedation would be filled out, would be completed, and then it would be kept in a safe server, which is currently with them. The cost, I think this is one of the biggest concerns that people have. It depends a lot on the complexity of the data gathered in a system similar, and so in a system that's similar to the current tool, it would cost $50,000 to $60,000 to create from scratch. That has already been paid by the AAPD, so that money you don't have to pay. It would cost anywhere from $2,000 to somewhere less than $10,000 to modify for use for the Dental Board of California. They would require a $30,000 annual maintenance fee to Dartmouth Bioinformatics, but for that money, you get everything that they offer. They will troubleshoot, they will control, they will help with the user interfaces, they will help assign the passwords, any problems or technical issues they will help sort out. They'll keep the platforms upgraded, they'll keep the data secure. So they do it all. You can choose as a board who would control the data. It can be controlled by members of the board, it could be controlled by an oversight committee within the board, it could be controlled by the AAPD since they're already using the data tool, or anyone else that you designate. So it's not, it's very flexible in terms, and it's not, the cost is not dependent on the number of patients enrolled. So you could enroll a few or you could enroll a lot, but obviously a data tool like this works best by having everybody use it. Data analysis is the fun and relatively easy part. This was Dr. Crivero's quote. She agrees. I don't know about that. But again, anyone that you decide on can control the data. Individuals that contribute to the data can access their own data with the group norms for benchmarking. So an individual practice, an individual group, an individual county or whatever, however it's broken down, can look and see how many sedations they're doing, what drugs they're using, what the age of their patient is, anything you can think of. They won't be able to see other people's data except as aggregated. So they'll see averages, they'll see what the state norms are for the group. And again, at every step of the way, members of this group are willing to help. The Dartmouth bioinformatics people are very, very easy to work with. Their suggestion is to consider an oversight committee early on to help maybe look at the data critically, develop potential guidelines, and develop and determine how you want to use the data. This is just a little bit more about them. They have a robust technical infrastructure. It's already been in place for over 15 years. It's already been used. It's been reliable. It's secure. They provide all the hardware, the development. They'll help test the services. They meet all information security regulations, so you don't have to be concerned about HIPAA violations. And they will grant the access to the personnel that need to have the access, and they will do all the encryption. So then the final question is, why not? Why would you not use this tool?
And I'm going to just say you've got about 3 minutes to wrap up. Is that going to be good?
That's going to be fine.
Awesome.
I'll be
Okay.
extremely respectful of
Okay,
time.
thank
Thank you
you.
very much. My name is Dr. James Tom. I'm the dentist anesthesiologist. I'm a clinical associate professor of dentistry over at the Herman Ostrow School of Dentistry at USC. I'm also the ADA representative for the ASA task force on the recent revisions on the guidelines on moderate sedation and analgesia. So it was a collaborative of a lot of healthcare professionals in regards to a lot of sedation and anesthesia that's being performed across the country. So why not? I think one of the things that we need to look at, especially in terms of patient safety and the collection of data, is to understand that groups such as us and other professionals and research groups need to establish ongoing continuous quality improvement initiatives, and this is one of them, and this is a really robust, and the framework has already been established. The ASA has already come out to say that most policymakers should implement and improve upon continuous quality improvement initiatives, and this indeed is a very, very strong program that can be adapted to California quite easily at minimal cost. The allegory and the analogy that I like to use is we are aware of the opioid crisis that's facing us here in the United States, and much of the data that has been collected because of prescription monitoring programs like Cures 2.0 has been used to direct basically the efforts in reducing opioid abuse and diversion. So with efforts such as this, the PSRC initiative and things, how they can be adapted to California, I think we can be the leaders in terms of providing quality data for meaningful change. So thank you very much for your time today. I want to thank my colleagues, and I really would encourage the board to consider our proposal. Thank you.
I think if we could have board members come back up, this is now an opportunity for you to ask some questions. And the speakers will be available to answer them.
That's correct.
We can turn it, yeah.
There we go.
Hey.
All right, thank you very much for that excellent presentation. Much appreciated, and thank you for respecting our time frame. Do we have, I see Dr. Chan's hand up.
I have to disclose that I previously worked with Dr. Chen in another board,
Yes.
but not on this subject matter.
That's correct. We're not in the same board for this subject.
There's a line.
Okay, thank you, Dr. Chan. Dr. Witcher.
Yeah, I hope if the other board members have questions, they have a chance to answer them. I have quite a bit. Yeah, I mean, I think we're all in favor of improving patient safety, and I think we all recognize the value of quality improvement and big data in doing that. And the thing, we can draw on a lot of other experience. You know, the anesthesiologists have really been at the forefront of this. And, you know, the PSRC studies, with which I'm familiar, are really excellent studies. And I have a lot to say about some of the data that was shown here, just because I think some of the comparisons between these different studies, the studies are not equivalent. They're not really comparable. And, you know, we can go into that in more detail. But, you know, the whole question of data reporting of near-miss events that don't result in serious death or injury is a valid one. And, you know, the reporting of these events has to be voluntary because it's unlikely that the providers are going to report accurate data if they're afraid of litigation and sanctions. And reporting, you know, has been, you know, we have this thing called incident reporting systems in the anesthesia profession that are designed to collect this data, and they're effective, but, you know, they don't work in a vacuum. They're only as good as the people using them. And, you know, one of the major limitations of incident reporting systems, even within highly motivated institutions, such as Wake Up Safe Initiative, which is, you know, being done at your institution, I know. The barriers to reporting include concern for punitive repercussions, feelings of incompetence, poor education about what constitutes an event, lack of feedback, and the perception that the reporting has no value. And the only way you can overcome those, you know, these things, they cause underreporting, is to really kind of go to work internally and cultivate a culture of safety where reporting is encouraged, there's reporter feedback, and then there's improved awareness of patient safety work. And it isn't just anesthesia, it exists in all aspects. I mean, for instance, we see patient injury in lots of different forms. Anesthesia is the only form we're talking about now, and I think the patient safety movement in general seeks to address more than that. Now, it's interesting because during the era of the Institute of Medicine report, a lot of patient safety work was done. And the federal government actually undertook to establish through an act of Congress the Patient Safety Act and Rule. And this set up entities known as patient safety organizations. And these were designed to provide a safe environment that's designed to encourage voluntary reporting of incidents that can be used to improve quality of care. Now, the problem with dentistry is it's a cottage industry. We don't have institutions within which we can do these constructs, such as QI things, so we need to figure that out. And I think what we're seeing happen is there's a number of reporting databases around the country that are being started up. One is the Dental Patient Safety Foundation. I know a lot of the professional associations are doing this. And so it's kind of going that way, but how it would be applied to multiple settings such as dental offices as opposed to institutions, I think that is an unanswered question. But anyway, so we have these patient safety organizations that are really kind of a safe haven for reporting. And there are uniform federal protections that apply to a provider's relationship with a PSO that remove these barriers and that would ordinarily deter participation in safety initiatives. So patient safety organizations, and I believe that AAPD, who is running this project, right? Yep. And I know I've talked to Dr. Liu about this a little bit, and I think it's a great project, and I really wish you success. The fact is, most patients say, and he told me that actually he would like to see their program become a PSO. That's eventually. Correct. I mean, not initially, but with time. And the thing that's important, and this is really the point that I'd like to make, is PSOs are safety-focused nonprofits, associations, institutes, and educational organizations that are eligible. And Wake Up Safe is a PSO, and so is the Anesthesia Quality Institute of the ASI. And these are a couple of the main organizations that are really driving this. I mean, Wake Up Safe's a great project. It's the oldest one. And, you know, they have the numbers to show. And there's a study I could go into a description of how they got there and what it took for them to get there, because it's an ongoing thing. It's not a done deal by any means. And so anyway, however, not every organization can become a PSO. And excluded organizations are A, health insurance carriers, regulatory agencies, or organizations that serve as their agents, accreditation and licensing entities, and entities that administer a state, federal, local, or tribal patient supporting system to which healthcare providers are required to report by law or regulation. In other words, it has to be the threat of sanctions and disciplinary action are not consistent with good reporting. It's a disincentive to reporting. So, you know, there's just kind of a quandary there. I would contend that it's fine for the board to encourage reporting, and that was the way the legislation was crafted, AB 2235. I think that was wise, because the minute the board steps into it, it takes on an overtone which is going to force things underground. You're going to get data, but it's not going to be good data, and it's not going to have the quality that you need. The other question is, you know, how are you going to do data quality assurance across thousands of dental offices around the state? I mean, you would have to go in and do chart audits or something like that, or somehow solve that problem. So again, it gets back to this fact that our presenter talked about. We need to get past shame and blame culture, hiding mistakes, improvement, fear, low morale. What we need is this culture of safety, where we recognize that systems contribute. We need to be able to speak openly about errors and mistakes, and the reporters need to know that their concerns are valued and acted upon, and the participants have to take ownership of this. And we've tried this in our group practice. We have an incident reporting system that we use internally. We do QI and QA on our outcomes, and it really works. I mean, it's amazing. I mean, you can really do problem solving, and I could give you some examples, and we're just doing it on a very small scale. You know, but again, I think it's a great idea. I think the role of the dental board should be rather supportive than direct, for the reasons that I've outlined. So, and I could speak about some of the studies that were shown and the good and the bad and the value of each, because they have great value if taken in the proper context. I just don't think you can necessarily extrapolate the results from Wake Up Safe to a completely different population and a completely different type of study. And so I'll leave that for another time and give you all a chance to answer questions.
Can I address that? So I may not look it, but I've actually been around for quite a long time and was there when Wake Up Safe was first proposed, and have been with institutions while all of the concerns that you voiced about, you know, people's concern about punitive issues. The thing that's really cool about this tool is that it's fast, it's easy, it's cheap. It also doesn't include patient information. So having a punitive aspect to it is automatically reduced because you don't have identifiers on there. The requirement could be part of licensing for sedation or for anesthesia, the provision of a general anesthesia license in the future, that you fill this out. And I agree, it has taken a long time for the anesthesia world to come to this point. I wouldn't have brought this to you 10 years ago because I think we were still contending with some of our own issues around reporting. You seem very familiar with the literature, which is outstanding. I'm thrilled to hear that, because I think you may have been quoting some of the papers from Stanford that just came out last year on that very topic of how do we get people to engage more with the reporting. Ours are now, our incident reporting for general anesthesia, not for sedation, is worked into our automatic data system. University of Colorado, which is where I was for 25 years before I came out here, was part of the pediatric sedation network, and they had somebody go through every sedation thing and make sure. So you're right, there's definitely issues. It's not as simple as we tried to make it sound. But I think the point that we're trying to make is that there will be people to help work it. There are dental offices, and there are individual offices around the country who donate this information, or who, because it is a donation, it's all voluntary through the Pediatric Research Consortium as of this time. But there are offices, there are practices, it's ED physicians, there are dentists, it's a small percentage. And they would love to see more dentists contributing information, because I believe, like you believe, I think what you're doing is safe for the most part. I think that there are, just like in anesthesia, there are some horrible things that can happen. And until we can figure out what it is that we can do to make that better, we're stuck. So I agree Wake Up Safe is a little bit different, but Don Tyler is a personal friend, just like Joe Crivero. There are people that I know that I've worked with. I've actually personally never been involved with either of the two databases that I quote. I'm just saying this is an example of data really showing, because people 5-10 years ago, we still hear it every day. Oh, doc, it's not the surgery I'm worried about, it's the anesthesia. And now we can turn to them and say, really, your risk of a major complication under anesthesia is incredibly low if you're otherwise healthy. Obviously, if you have other medical issues, it's a little bit different story. So I hear you, and I really appreciate the fact that you've clearly done a lot of research and are very knowledgeable about this area. But I think from everything that we hear that it would be doable. Now, the role of the board in this, all I know is from the law that it's, that it's something that they really want to have the board at least think about a data gathering tool. And I don't think that legal liability or any of that would be an issue, since it's all de-identified information that's submitted. You wouldn't know necessarily with this particular tool names of patients, unless that was something you chose to dig into further.
I'm going to just add a little bit more. Thank you for your comment. I really like your comments about the data's quality, and that is the key. So AAPD already have this project. The data quality, it is something that you should concern. When it's voluntary data, when it's near miss, yes, most of people will be afraid to enter. But however, I know the board, it's mandatory to report death or severe harm. So that's mandatory. So at least we will have that data available. And when we know how many total sedation is performed, that is the importance. 3 out of 1,000 compared to 3 out of 1 million. That is very different. So that will show the quality. So when we are practicing dentistry or healthcare, right now is all evidence-based driven. So you have to have evidence. You cannot just say, oh, I guess the risk is about 30% success rate. I really hate to do that. So what AAPD is trying to do is try to make sure we have that total number to show what is a relevant risk. And how come the AAPD, that project will work is because we're all program director. We're going to force all our residents to make sure they log everything. But for the private practitioner, it will be hard. I understand it will be hard. And that's why we propose to the board. The board is the one who's regulate. So that's why we believe the board is the one that has the force, has the power to encourage everyone to improve their practice safety. And also that will be evidence to help us, to help the board to develop and guide next steps. When you are saying sedation permit, it's 60 hours of this. Well, how did you come up with 60? How did you come up with 7.5 hours enough? How do you know which medication you can use? If we use this medication, we found some medication is totally dangerous, then we may be able to eliminate, or only certain people have certain permit can use. So this will be a very useful resources for the board. So that's my point.
Well, I'd like to address that. I think I think when PSOs were set up, I think that was well thought out. And I think that there were limitations put on who can become a PSO for very good reasons. And I just think that, we have some basic reporting that we are required by law to do. And I think that's good. I think we all support that. Those are the serious outcomes, and we know the drawback there is not going to be the numbers. Now, what I would like to see is that the board does keep track of the case numbers. I think if we go much beyond that, it's going to, there's just going to be this overtone that's going to discourage getting good data. You'll get data, but, will it really represent what's happening out there in individual offices where people, like I say, it's hard enough to get there in a supportive environment. If that's missing, I just don't think it's going to work very well. You will do something, everybody wants to use the legislative hammer on this. I think that's really kind of inconsistent with the way this operates. So I would just say that the board can play a role in this, maybe a supportive role, where we encourage reporting, but I think mandatory reporting would be a big mistake.
Thank you, Dr. Witcher. At this point, I'd like to ask for any public comment. Seeing none, I just want to thank each of you for presenting today. I will tell you that this general dentist doesn't understand much about data collection and quality data, but you've made me more aware of the issue, and I very much appreciate your time and your presentation, and certainly your credentials are very, very impressive. So thank you for being with us. We will take this information under consideration, and we'll go from there, and thank you.
And I just want to add, please feel free to contact any of us at any time with any questions. Well, Dr. Kaplan, you have her information. She can put us in touch. So please do. We'd love to talk about this more. I know it's a lot to take in, but it can be done so it's not thought of as a punitive thing, and it's not thought of as a negative, but a positive.
Thank you very much. Thank you. All right, we're back on page 4 of 5, and it's agenda item C, discussion and possible action regarding draft statutory language to update definitions for general anesthesia, conscious sedation, and oral sedation for pediatrics and adults.
So this is 9C. Sorry, gets a bit confusing. Okay, so if everybody's found their place, I'll try to explain this as succinctly as possible. So if you read the background that I put together, essentially, the board is aware that during the last year, 2017, there were different stakeholder organizations that were trying to move forward the board's recommendations. The study that was done on pediatric anesthesia and was submitted to the legislature by January 1st of 2016, I've lost track now, essentially said that the statute and regulations currently on the books do provide public safety. However, the board came up with 5 additional recommendations and put that forth to Senator Hill that said these recommendations could enhance the issue of safety for pediatric patients undergoing sedation. There were a number of bills the board was following last year. None of them ended up going anywhere so far. So we were approached by some stakeholders who were interested in saying, perhaps the board would be interested in being actively involved in the formulation of language going forward that will be taking baby steps toward trying to implement some of the recommendations we put forth. What you have before you is our staff's best attempt at revising the definitions of general anesthesia and the certain levels of sedation in statute at this point. These definitions mirror the definitions at the national level, and within all the pieces of legislation that were introduced last year, stakeholders appeared to have agreed with these definitions. So we have put this language forward for the board to review. The language essentially is doing just as I said. We're striking the language that's been there on our books and substituting the language that's out there with the ADA and other national organizations. We've also addressed the use of capnography. There are a number of sections of law that are here that are, you can see the changes because they're essentially relative to the main sections. So if we changed it in one section of law, we wanted to make sure that if it referred to the old definition in another section of law, that we tried to correct that at the same time. So again, this is the attempt at baby steps to move the board's recommendations forward. We tried to take what we considered non-controversial issues and at least start a process. And at this point, I guess we open it up for discussion if there is any, or questions.
Could I make a comment? For those of you who are around and maybe those of you who are new, you might want to know by way of background that Dr. Lay and I were on a subcommittee back in 2010 to look at updating the definitions, and we made some recommendations at that time. We went away and worked on that for a few years. We worked with a collaborative stakeholder group during most of 2012 and came back with a proposal to update the statutes in 2013, which we presented to the board. We chose not to move that forward at the time. We came very close to achieving a pretty good consensus on many aspects of anesthesia and sedation care, and I saw that as an opportunity, but it had to wait. What we did learn during that group were these were some of the elements that everybody could agree on, and I think over the last few years we have learned that for the most part, and I think the bit on capnography there might be still some disagreement on, but certainly the definitions, I think, our stakeholders in other professions and so on would agree are something that could move forward. So I think there is an opportunity to do here to maybe take this in baby steps and basically continue a project that has been going for as long as I've been on the board. So now whether this will go anywhere, I couldn't really predict because that depends on the vagaries of the legislative process, but it's worth a try.
Thank you, Dr. Witcher. Further comments?
So I wanted to say that this is an action item. I didn't include that in the memo, but the action item is essentially we need to know whether the board accepts this language, approves this language. The reason for that is this language could miraculously find itself in a piece of legislation that's already in process. And therefore, if the board has already agreed to this language, we would be in support of that legislation moving forward. Also, in the event that this language does not find itself miraculously in a piece of legislation that'll be going forward now, we'll have a good start in the next session, the next legislative session next year, and perhaps through our sunset review period to move this forward if it doesn't go forward now. But the hope is essentially that board members were able to review this material, see that in essence it does update the definitions, and this would be the board's first attempt, if you will, of either co-sponsoring or sponsoring language that's going to move forward.
Yes, Fran, Ms. Burton.
To kind of move this process and allow for further questions, I'd like to move a support. And then we can continue our discussion.
Generally, for the change in language and definitions, highly agree with that. There is, just to restate one of the comments that Dr. Witcher had about capnography, that it does appear to be a increasing industry standard. However, it's not the pure early warning system that can be hoped for. There is a delay from the time when the action happens and then when it's reported by the capnography. So we shouldn't rely purely on that as, again, the early warning system to stop an unfortunate event.
Yeah, just response. This is not a complete proposal. This is just an attempt to move the parts forward. As far as warning system goes, capnography, I think we all agree, has a place. Current standards and regulations that we have, have various levels of specificity, but they do imply that there should be more than one method. In other words, a precordial stethoscope, pulse oximetry, and capnography should all really be used, as well as watching the patient. And that's kind of the professional standard in anesthesia or sedation care. But, some of those are in place already. Capnography, for the role of capnography in moderate sedation is a new move that would be part of this proposal. But all the other stuff is kind of existing.
Further board comment? Seeing none, Dr. Rigiardo?
Thank you. Paul Rigiardo with the California Society of Pediatric Dentistry. In looking at this, I've noted that the draft language still keeps the term oral conscious sedation instead of minimal sedation. And if the attempt here is to coordinate this to be consistent with national guidelines all have eliminated oral conscious sedation and use the words minimal sedation. What is the reasoning for retaining oral conscious sedation here instead of minimal sedation throughout the document?
I was hoping somebody would ask that.
It's my pleasure.
Through the chair, could I ask Sarah?
Please.
Are you willing to respond?
As the three bills that were introduced last year were going through the process, the board was tasked with the question as to what the potential fiscal impact could be. And one of the biggest fiscal impacts we incur when legislation is passed is relating to our BREEZE system. And as we've reported in other scenarios of implementation, changes to the BREEZE system can take a long period of time and they can be costly. And so bottom line, what we were trying to create at the staff level was a proposal that would have the most minimal fiscal impact while still able to implement the definitions that the board had recommended be moved forward. So it really comes down to a system capability issue and minimizing the amount of potential changes that we would have to make to the system and minimizing that fiscal impact that's involved.
It isn't a very pure product, and such are the concessions that we sometimes have to make. The other point is you will notice that Section 2.85 that has to do with adult oral conscious sedation has not changed. I don't know if you remember this, but during the discussions in 2016, the decision was made by the board to focus on pediatrics and leave the adults out of it, with the idea that maybe we would come back and look at that later. So that's the reason that's out. The current legislative proposals, none of them repeal 2.85. So effectively, all the legislative proposals retain that language in one way or another as it applies to moderate oral conscious sedation. It's just that there was previous, in the proposals, there is more a minimal sedation category that's defined specifically as such, whereas here we couch that in the framework of oral conscious sedation as a holdover from when we had the pediatric oral conscious sedation permit, or the permit for minors, I guess it's more correctly termed.
Sure. If I might, then, it appears that this draft language then is just kicking the can down the road. And this is still something the board would have to address at some point in the not too distant future and would have to still solve. Why create something here that just requires further correction later?
Well, the idea was to take the pieces we could agree upon and move those, realizing that it's not the last chapter. We know that even if one of the two bills passed, there would still be work to do.
Thank you.
Mary McCune, CDA. CDA is pretty pleased to see the amendments in this meeting's board packet. We just wanted to let the board know as an FYI that we've been working with CalAMUS and CSPD and a couple other stakeholders for amendments for SB 501, and they include, among other things, this exact same language. So we hope as that bill progresses that we can see the language that I'm assuming this board will probably approve or agree upon in SB 501 or whichever bill moves forward. So thank you.
Mr. President, Gary Cooper representing CalAMUS, and I think most of you have seen me here before talking about a similar issue. We are the stakeholder. There's no secret here. In all transparency, Karen didn't put it in writing, but we are the stakeholder that came to Karen and asked her if she would have the staff draft some language that we could agree on, that most parties that have ever been around the table can agree on. And primarily, when Karen and I had some discussions, the two subjects that came up were the definitions and capnography. So I asked if she could have her staff put together some language dealing with both of those issues. As Mary just indicated from CDA, the language that you're looking at, dealing specifically with capnography, is the same language that's in proposed amendments to SB 501 that never saw the light of day, or it will at some point, hopefully, but it was proposed and it's still sitting in the Assembly Appropriations Committee. So that language was already agreed upon between the pediatric dentists and CDA and the oral surgeons. With regard to the definitions, those have already been stated. Those are pretty much standard within ASA, and we wanted to codify that. And we thought those two steps would be a good opportunity for us, as I said, to take baby steps and deal with what has been going on now for the last 3 years. Your last presentation, obviously, Dr. Kaplan, she was very intimately involved with the situation. And we have, hopefully, that we can do something to make the situation a little bit safer. We can't do everything. We can't do everything that she would like immediately. We can't do everything that we would like immediately. But hopefully, with this baby step, we can offer the legislature and the families out there and the profession something to say, look, we are working on it. You as a board came back with a recommendation a year and a half ago and said, do this. And so far, nothing has been done, and we're not beating you up. It's just unfortunately the way the process works, and we hope this will get something moving. And with that, I'd like to introduce Dr. Elo, who is the president of CalAMUS.
Hi, Jeff Elo, President CalAMUS this year. I just wanted to echo what's already been said by the last couple of speakers, but it really is CalAMUS's desire to implement in statute the items that we know will improve patient safety. And we believe that's capnography for the use of deep sedation and general anesthesia. We also believe that by updating the definitions of the levels of anesthesia to meet those defined by the American Society of Anesthesiologists, that we'll all be speaking the same language because we'll be using the same terms. So that's about the only other thing I have to add in addition to what Gary said.
Thank you, Dr. Elo. That's helpful. Karen?
I have a comment too. Gary, implied I have more power than I have. So I
You have
just want
lots
to
of power.
clarify for the record that this decision was discussed among our board president and our legislative chair. So they were brought into this discussion, and that's how we got to where we are going. Typically, staff does not put together language based on a stakeholder's request to do so, but he's right in that I thought that this would move the board's recommendations forward, and hopefully we can get some language passed that will at least update our definitions. So that's where that came from.
Mr. President, one last thing I'd like to add, and that is that, as Karen said earlier, if this language, we cannot get it in 501 as we would like to do because there is a bill that's viable out there, we will then certainly go and attempt to put it in another moving vehicle and get this language in statute. So where our hopes is it will be 501. I can go back to the Assembly where the bill is right now and say this is something that's been pretty much agreed upon. If it turns out we cannot do it in 501, then we will make every effort to put it in a vehicle that we can move it in.
Good. Thank you, Dr. Cooper. Appreciate that.
Thank you.
So, do we have a motion
A motion
and a second?
to support the language. Looks like Dr. Witcher.
Dr. Witcher?
You know, again, I guess I need a little clarification here. I mean, I thought the idea behind this was that the general feeling was that 501 was not going to get out of committee.
That's not necessarily the case. I mean, obviously, as you're looking at it right now, it's sitting in the Assembly Appropriations Committee. It is still a bill that can be moved. We've had comments from the Assembly Appropriations Committee saying that what she's tried to do over a period of time is try to get stakeholders together to discuss that bill. It's still very viable. It still can be moved if there is the political will to move it. There's certainly will on our part to move it, and if we can put some language in there that we can get a general consensus, then we will move heaven and earth to try to get that bill to move. That is our bill. SB 392, as was indicated earlier, was our bill as well, but we graciously gave it to Senator Bates to use for something else. But SB 501 continues to be our bill, and we will certainly hope to be able to move that, our current language into that, and that would be the only thing in that bill. It would not be what's in 501 now. It would be only what we're talking about here today.
I guess I just wouldn't want this to undermine the efforts to pass 501 or some negotiated variant thereof, because it's a chance to get this done this year.
I don't think that's a question for us, Dr. Witcher.
Thank you. Thank you.
All right. Thank you, Dr. Cooper. We have a motion on the floor and a second. I think we're ready to take that vote.
Burton? Yes. Chan? Yes. Chappelle and Ingram, absent. Lai? Yes. Laren? Yes. Lay? Yes. McKenzie?
Yes.
Medina's absent. Morrow? Olag? Pacheco? Stewart?
Yes.
Witcher? And Dr. Yu is absent also. The motion passes.
Due to the hour, I think we're going to. Oh, thank you. Due to the hour, I think we're going to recess and go into closed session, and we'll take up the rest of the work in the morning. 8:30. 8 o'clock, pardon me. 8 o'clock? Thank you.